Welcome to the Diversity Connector podcast, where we explore the rich tapestry of human experiences. I'm your host, Getrude Matshe, and I'd like to acknowledge the traditional custodians of the country on which we meet today. I would also like to pay my respects to elders, past, present, and emerging, and together as we dive into conversations that bridge cultures, challenge stereotypes, and celebrate the unique perspectives each of us brings to the table. Each episode is a journey through stories and insights from a kaleidoscope of voices, each sharing their colorful narrative. Whether you're at home, on the go, or just anywhere in between, you're now part of a community that values understanding, inclusivity, and the beauty of diversity. So plug in your headphones, get comfortable, and let's connect through the power of our shared stories. Welcome, and thank you for joining us on the Diversity Connector podcast. Hello, everybody, and welcome back to the HerStory Circle. This is Getrude Matshe here in beautiful Melbourne, Australia. And today I am graced with the presence of yet another fascinating woman. Welcome, welcome, welcome to our tribe. Please tell everybody your full name, where you're based, and share your story with us today.
Thank you, Getrude, for having me here. My name is Komaljeet Kaur. I am a family law attorney based in California, in the United States. I have been practicing family law exclusively. I've been in the field for almost 7 years. This all started, a few years ago when I clerked for a judge in Santa Clara County. And I finally got over the fear of family law. I did grow up in a domestic violence household. And, I was exposed to divorce and domestic violence early on in my life. So I always shied away from going into family law. So I tried different areas of law like immigration, bankruptcy, civil cases, but it didn't feel like my calling. I knew I was able to really, handle a lot of stress and work great under pressure and kind of think logically. So I think that's, why I became a lawyer in the first place. And, once I did that judicial internship, I got to see lawyers, I got to see judges really put the children at the center stage of a divorce proceeding. So I really thought like, okay, I feel like if my parents had a little bit more guidance, better representation, and just really focus on the children and the effects of the divorce and domestic violence on children, it would have made a huge difference on my childhood. And, so that's why I kind of got into family law, thinking I could help educate our community and kind of focus the attention on the children versus all the, also navigate through all the emotions and all the changes that are happening during the divorce process. So that's kind of my origin story. And that's why I am an advocate of, for domestic violence victims, as well as I strongly care about the children and the effects of divorce and, relationships ending on the children. Yes, I think what inspired me to become a family law attorney was kind of seeing no representation for someone like me. So, for example, somebody that's American Indian that grew up here, and for children with that type of background, I like when I was a child, like my parents were going through a divorce, and I had no idea what was going on. No one talked to me about it. I didn't have any friends to talk about it with, teachers. So just trying to find, that information and that resource for people like my parents that don't understand the law, that don't understand the language, and kind of breaking it down for them so they're able to get their legal rights heard, as well as focus and, kind of decrease the impact of divorce and domestic violence on their children. So just kind of making the divorce process easier and, seamless as possible. That's kind of my goal. And that's what inspires me. What's inspired me to become a family law attorney. I suggest the parents kind of talking to the child and letting them know that, mom and dad still love you, but you're going to have two separate homes now. So there's a lot of books out there that kind of talk about divorce and how to go about speaking that with your child. Therapy is also helpful during this transition period, so the child has a safe place to talk about the effects and the separation and separation anxiety he or she may have when there's all this huge change going on. So I do recommend therapy for the child. I do recommend reading books to them, children's books about divorce and separation. I don't recommend, it's also the court doesn't recommend that the children are exposed to anything regarding the divorce, no making disparaging statements about the other parent to the child. We have to remember that the child is one half of mom and one half of father. So you should always, speak highly of each other, of each other in front of the child. And, from going into from husband and wife mode, you should start shifting into co-parenting mode. So the more that you guys understand that you have to work as a team to help your child for the next 18 years, the better it will be for you as well as the children. So, a child needs both their parents, and a divorce and a separation should not impact that right of that child, as well as that importance of that bond with both parents. Yes, I think the hardest part of child custody cases is really understanding that we're dealing with a child here. Regardless of the child's age, that child should be the center focus of this divorce process. So it's really hard when the child is young, but it's also very hard when the child is a teenager. The effects of the divorce, it doesn't matter if the child is young or older, it's still going to affect the child, especially if there's domestic violence as well involved. So, we have to work together as well as with the court to figure out what's in the best interest of the child. And the sad part is even if there's domestic violence involved and the child witnessed the domestic violence, the abuser still might have visitation with the child. So the court is very cautious of keeping that relationship with both sides of mom and dad. But there's just so much unfolding in a divorce process, especially if there's domestic violence. But we have to understand that ongoing contact with each parent is very important. So the thing with young children, how are they going to spend a day, 2 days, 3 days, 4 days apart from each parent? What type of visitation schedule would be best for them? I think that is very hard for young children, transitioning and going to school, holiday schedules, vacation schedules, traveling. How are we going to talk about all that stuff? Before, when that mom and dad were in one household, it was very informal. Now they have to ask each other for permission, and which is really hard when they're going through a separation. There's a whole, emotional aspect of that going on as well. So it's just kind of, like I said, transitioning into the co-parenting relationship that helps the children. With teenage children, they're growing, they're changing, they have their own opinions about the separation, about the divorce process. So if they get involved, there might, if the parents are making disparaging statements about one another, or talking to them about the divorce, or not participating in visitation, or like if they notice that mom and dad's not showing up for my school events, they're not showing up for visitation, that's going to have an impact on their relationship with the parent. And if one parent is trying to isolate the child from the other and say things that could lead to parental alienation, which has even more long-term effects on the child. So child custody is just a very complex and very stressful type of divorce case. So I would say that, child custody, whether it's with young children or older children, those are always the hardest case, because we're trying to limit the impact on the children. We have, the judges, the attorneys, minors counsels, emergency screeners, therapists. Everybody's main goal is to, focus on the best interest of the children. Yes. So even before getting a domestic violence restraining order, before, you're able to gather the information and the forms, I think that's one of the first struggles. How do I get a domestic violence restraining order? Where do I go? How do I fill out the forms? I think that's the number one struggle. But what I recommend my clients and, just anybody that's going through domestic violence is start documenting it. And if you're under threat, if your children are under threat, you contact the police. You tell your healthcare providers, you tell somebody that you're going through a domestic violence, so there's a record of that. And when you're contacting the police and this incident is happening right now, you ask the police for an emergency protective order, so you have that protection pending you getting a domestic violence restraining order. So that's kind of something you could do in the meantime while you're getting your paperwork and going to court to file a restraining order. So to get the restraining order, you need to have timelines of the incidents and the type of abuse you've suffered and for how long, who was there, who was the witnesses. So you want to have like a declaration from you that that says all this information. So start keeping notes, diary of everything that's happening. If you have pictures, you want to have that for filing that restraining order. You want to get all the information about where that person is, and so that it'll be easier for you to serve that person the domestic violence restraining order. You also want to start thinking about what your requests are going to be in the restraining order. Are you going to ask for spousal support? Are you going to ask for attorney's fees? Are you going to ask for child custody? Are you going to ask for a move out order so you and your children can stay in that home while you guys cool off and deal with this domestic violence restraining order? You decide if you want to get a permanent or restraining order or a temporary restraining order. So once you fill out all the forms, you can go to the court, or you can go to the self-help if you don't have the resources to afford an attorney, or you can go to an attorney. They'll help you fill out the forms. It'll be submitted with all the evidence to the judge. The judge will make temporary orders to grant or deny your request. You'll get that back, and if they're granted, you can go and serve that other person. So somebody 18 years or older unrelated to the case, you can use a process server. Or any family member or a friend, anybody but you can serve that to them, and those orders will come into effect. So automatically that person has a restraining order on them, and they will be registered in the CLETS restraining system. So if any violations occur, they will be arrested. So it's very important for them to get served, the domestic violence restraining order once it's been granted. So they'll give a hearing date as well to discuss the restraining order, because the other side will have their opportunity to be heard in court on the allegations and the grounds of that restraining order. So they have 30 days to file their response. At that first hearing, they'll file that response, or their request for a continuance to get a response going. They might request visitation. The judge might address some of your requests at that time, or they might just continue it. What you have is a temporary restraining order. If you want to get a permanent restraining order, there has to be a trial. The judge has to hear both sides of what happened and make a determination by a preponderance of evidence of whether domestic violence occurred or not. So if the judge finds that there was domestic violence, then you will get a permanent restraining order for 1 year, 2 years, up to 5 years. You can get that. The problem is that trials are very expensive, and having witnesses and exhibits and cross-examinations, preparing somebody for a trial, and having a domestic violence victim go to court, see their abuser, and stand up for themselves, it's very hard. So sometimes you can end up settling the case and just agree that you stay away from me, I get to keep the house. It's called a peaceful conduct order. Some people opt to choose that and kind of just say that I've cooled off. I think that person has learned their lesson. I either want to just get a divorce now, or I want to just drop this restraining order and just move on with the divorce process, and just have these terms, because that DVRO, the domestic violence restraining order, stays on that person's record. So if that person has to go work, he or she is the only employed person there, it's going to limit their ability to find employment or maintain employment. So a restraining order is a big deal, and having it on your record is a big deal. But you also have to weigh, is it important for you to keep that restraining order? So if that person keeps violating that restraining order and you are afraid of your life and safety, it's in your best interest to go to trial and get that permanent restraining order for you and your child. You can also, in the DVRO, in the restraining order process, you can also ask that the children be added as protected parties if they were witnesses to the domestic violence, and if they are threatened by that as well. So because of that, the other side, the abuser might not get visitation. They might have things like supervised visits through a professional or a non-professional. So that's kind of the process of the getting a restraining order. So trial is probably the hardest part about getting that restraining order to be permanent. So you can decide how you want to pursue that. If you want to just have a temporary restraining order so that you can cool off and figure out if you want to get a permanent restraining order, completely your decision. Um, and then later on, you can get that restraining renewed as well. If there's grounds for that, you can petition the court to get it renewed as well for another year, 2 years. So it's a very powerful tool for domestic violence victims as well, if that restraining order. So property division is a critical part of a divorce. A lot of people, they don't even know that once they get married, their finances become one as well. So their finances, their debts, everything becomes one. California is one state that is a community property state. So you want to check about, when you get married, is it community property or is it separate property? So for example, with California, from the date of marriage to the date of separation, anything that you acquired, the assets or debts, they're all subject to community property laws, which means it's going to be divided 50-50. So when we're dealing with, property division, the second step of the divorce is doing preliminary financial disclosures. So each husband and wife, they have a fiduciary duty to disclose everything truthfully and provide statements and documentation. So husband and wives, like partners, they're basically like business partners. They need to know what's going on with all their assets and debts. And surprisingly, most of them don't know during the marriage because one of them is the managing spouse and the other person just kind of signs checks or just not aware of it. They're doing other tasks instead. So, during that critical stage and that second step, that preliminary disclosures, each party, discloses all their finances and debts. And, we can see side by side who has what. And that kind of helps us in the settlement negotiations and to figure out what would be a fair result of how we're going to divide these assets. The number one thing I look for is kind of, if there's businesses, if there's houses, I want to start planning on what's going to happen with those major assets first. So with the house, it's either going to be sold or that it's going to be one person has to buy out the other person's interest in their half of the house. And that's something that we can talk. I like to talk about right early on in the case, where it's like, what's your main priority? Do you want to keep the house, or are you okay with selling the house? Because the house is a very sentimental item, and if you have small children, how we can get to keep that house, for one of the parties, that's very important as well. So property division, there's a lot of other tools that we can talk to, the other side. We can negotiate. We can send each other letters, meet and confer with the other side's attorney. We can go to settlement officer conferences where we have like a third attorney present, where they are neutral and they kind of let us know, like, hey, if you guys were to proceed to trial in court, this would be the outcome. So you can meet each other halfway. There's no one can like force people to sign an agreement that they don't want to do. But, if there's an amicable result that we can achieve in settlement negotiations, I always try to do that and try to keep the cost low for my clients as well. But if, both sides don't agree on what to do with the house or the assets, or there's differences on if this is community property or separate property, or where this asset comes from and how much the asset is worth, we also need to hire experts. We might need to go to trial. So a chunk of our time really is spent on property division. So the most complicated cases involve child custody issues, a lot of property division, domestic violence. Those would be the more complex cases. But now we see a lot of more cases where it's like people are married for 20 years, 30 years, and they have so many assets together, like with retirement accounts and with the houses and property. It's just the sooner we get started on dealing with those assets and untangling those and figuring out how we can fairly divide them, the better. So I'm more proactive with analyzing and getting all that asset information and debt information so we can propose a global settlement offer to kind of talk about settlement negotiations and start that discussion sooner than later. The divorce process in California takes about 6 months and a day, but due to these property division issues and custody issues, it might take longer. So I kind of like to just hit the floor running and trying to talk about all the major goals and major assets with my client in the first few meetings, so we are aligned on the same page, and that we don't really delay the case, and we prioritize whatever the client is focused on. For example, if they really want to keep the house, how can we work with our finances and work with the other party to make sure that we keep the house for you and the children?
Very, very complex issues that you have to deal with when you're navigating divorce. So, in your experience, what are the key factors that influence the outcome of a trial in family law?
So there are several factors that impact, the results of a family law trial. There's divorce trials on like property division issues, or there might be one or two major issues that you need to go to trial for. And you just need to prepare your arguments. You want to prepare your witnesses, prepare your exhibits. If you anything that could help you show the court and that this is the correct, the way of handling this issue. There's also domestic violence trials, which are harder, and you have to prepare, all the witnesses. You have to prepare the client. So that's kind of, I spend more time there, because it all depends on your credibility in court and you remembering the details, as well as, how we're able to kind of demonstrate to the court, your credibility, as well as with the facts that occurred during those domestic violence incidents that are documented in our pleading papers. So I would say that, making sure that you have prepared, the everybody that's testifying, as well as your documentation, making sure you lodge everything with the court, making sure that you are aware of every facts in your case, that your case, like at the back of your hand, getting those critical dates. That's very important. So you're presenting the case during a trial. So you want to put your best foot forward. You want to make sure that you come across as credible and genuine. So preparing those witnesses, making sure they're witnesses and exhibits and evidence that's relevant to making your case. So a lot of it is trial prep. So having a good trial brief, making good decisions of using that time and that money for trial prep properly. So I think having a good trial plan and trial prep, where you prepare the witnesses, you prepare your evidence, you select all of that carefully, that is the most important step and impact that it impacts your trial results.
You're skilled in a variety of legal programs like Westlaw and Nexus Lexus. How do these tools enhance your ability to serve your clients effectively?
Yes, so tools like LexisNexis, Westlaw, there's case text as well. They really help with legal research when we're preparing for trial. There's always a case that's very similar to our case. So if we look for the pattern, we use that, to argue against or in favor of our client's position. So those type of legal research tools are critical for us preparing for any case and making our argument. I really use them a lot for preparing for trials. What we have is called memorandums of points and authorities, the case law that supports our motions. So for legal research, it's important that we get those legal authorities and current case law from those legal resources. So I love having tools like that, where I could check current case law and I could cite case law in my cases. And I could also, compare and contrast my case with other previous cases in history that have happened, and use that to strengthen our arguments, on paper, as well as, in an argument in trial as well.
It's very, very thorough, all the things you have to do and to consider. So, can you explain the importance of motions like motions to dismiss, motion to quench summons in the context of family law?
Yes.
There's all the jargon that we get thrown when you are involved in law.
Yes. So motions to dismiss and motions to quash summons, that's something that's when related to family law. motion to quash summons is mostly jurisdiction based. So a lot of people, they might be citizens of a different state or a different country. They're like, I got married in a different country. The court has no jurisdiction over me. We should get the divorce in this country instead. So depending on the jurisdiction, if the court has jurisdiction or not, you can file that motion to quash summons. Once you receive a petition for a divorce, you have 30 days to file that motion to quash summons. So, but so you really have to look at the residency requirements and jurisdiction requirements before you file that divorce case in whatever county, country, or state you file it in. So you always have that resource of filing that motion to quash summons if you receive a petition, and it's all jurisdictional based. A motion to dismiss is, during the divorce process, the petitioner. So if you started the divorce, you always have, there's stages in the divorce where you can kind of dismiss the case if the other person has not appeared in the case. But at any time, if you agree to dismiss the divorce case and the other side and they have appeared and they agree to dismiss the case as well, both of you can, fill out a form and to request a dismissal of the divorce case altogether. So there's always, exit strategies. If somewhere down the road you decide like, okay, I want to give my relationship another chance, I want to dismiss this case. But both of you, there's a stage where it's, one person has to dismiss it through paperwork. But when the other side appears and says, no, I don't want to dismiss this divorce, I want to move forward with the divorce, then you have to get both parties to agree to that motion to dismiss. So you can always dismiss the case, but it all depends on what stage of the divorce case we are in and if the other party agrees, if they've already appeared.
Now, discovery is a critical phase in litigation. Can you share some strategies you employ during this phase to strengthen your client's case?
Yeah, so discovery is a very important tool that we all have to kind of get more information or information that is being withheld or missing, and that's more than required. So there's standard documents and statements and current statements that are required in the preliminary financial disclosures. But if you want to go back, 2 years, 5 years, 10 years, and you have specific issues and assets that you want to inquire about, we might need to issue subpoenas. We might need to do special interrogatories and, this special types of discovery to figure out the answers to your questions. So early on in the case, I like to ask, my clients, like, is there a business or an asset that you have no idea about that you want to learn more about? Maybe one person is the managing spouse of all the assets, you don't have information to all of that, all the back statements. We can get that through discovery. We can narrow the scope of discovery so we can figure out, if someone has, for example, they're saying that some person has been funneling money somewhere else or sending it to a different account. We can look at that time frame and figure out if that was happening or not. So really tailoring the question, the search, the quest, the reason why we're doing the discovery, I think that is critical. So asking our clients for like the timelines and what they are particularly looking for, like what piece of the puzzle is missing for them to make a fair settlement agreement. And that, I think that's what discovery really helps us get to the bottom of. So we get some information, but we need more information because the snapshot is not enough. So that discovery tool is there to help clients get more information about businesses, about assets, about retirement accounts, about employment. So that's always a tool that can help them feel more assured that they want something more than the standard paperwork. So discovery, we start preparing for discovery way in advance because there's a deadline for discovery. It's prompt deadlines. We don't want to miss all those deadlines. And it takes time to comply with those deadlines. So preparing on the first few meetings with the client, we figure out if we need discovery or not. And we have that discussion about discovery and the cost and timeline that goes into discovery. So that step is discussed early on in the case. And I think that's very critical as well, having that talk about the important resource that discovery is.
Now, as a family law attorney, how do you manage the emotional and psychological impact of legal disputes with your clients?
So family law, when you have children and your relationship is ending, it takes an enormous toll on you emotional and psychologically. So when I meet my clients for the first time, I'm just sitting there, getting to know more about them, their story, what led them to coming to my office, what's their main concerns, what's their goals with this divorce, how can I help them on this journey. So I refer them to therapists. I connect them to the right people, whatever support system they need. I'm also one of their greatest allies on this journey. And I tell them, like, we're going to be best friends for the next 6 months or longer. And anything you need, any thoughts that you have, any anxiety you have, you share that with me. So, I'm just a call away, just an email away, that I need to keep a close eye on you so that, I know that you're safe and that we're moving smoothly in this divorce case. And it's often easier for somebody that's outside of the relationship ending, for example, outside the parties, like attorneys, because we are not going through the same emotions and that tragedy and trauma from a short, whether it's a short-term or long-term relationship or marriage. It takes a lot. It takes a huge toll on that person. So as an attorney, it's my job to protect the legal interest of my client and kind of be the voice of reason to guide them in this emotional process by taking, the just they work on healing, and they work on themselves, and just I help them through all the legal procedures. I guide them, I do the paperwork for them, so that they can just focus on healing and moving forward with their life, focused on their children. So as an attorney, I take the footwork and the guesswork out of the divorce process, and kind of always keep their best interest in mind. And I always give my clients, like, hey, this is our vehicle of how to get from start to finish. You are in the driver's seat, but I'm in the like, you're in the driver's seat. I'll tell you which way to go, but at any time you want to put on the brakes, you're in charge. Like, I am never going to force you to agree, or or agree or disagree to anything that you don't feel comfortable with. I'm just here to empower you on this journey. This journey is yours. I am just an ally. So I reiterate that to my clients, to make sure that they feel in control and they're empowered with this legal knowledge, and by having an attorney by their side. It's just so hard. It's such an emotional roller coaster. You have friends, you have family, everybody giving you opinion, and that makes it really hard for clients to move on and heal and just focus on their divorce. So I feel having an attorney that's unbiased, that has no incentive, that's really important to have for somebody that's going through a divorce process.
Wow, so much to take in when you're navigating this space. So my last question for you is, looking forwards, are there any changes or developments in family law that you think are particularly significant or that you're excited about?
I think one of the developments in family law that I've seen recently is just psychology taking a huge role in the divorce process. There's more cases and there's more situations where narcissism is really in play. So as legal professionals, we have to be aware of these type of personality disorders, about narcissism and how it affects the divorce results. How, as attorneys, we handle a party that is a narcissist when my client tells me that. So there's more information coming out with negotiating with narcissist, and that when my client tells me, like, there's a narcissist on the other side, that starts, we change our strategy based on that. Because sometimes we look at the client, a domestic violence client, or somebody who's been living with a narcissist. They always they always want to settle the case, but narcissists want to push they don't want to agree to anything, right? So as an attorney, learning about narcissism and the effects of it on a divorce case and the effects of it on my client's health, I feel that is a huge development. And understanding how that narcissist works, it's that psychological element that's coming into divorce cases, and how that affects, even when there's children involved as well. So I feel that, personality disorders and mental health, of children as well as the parties is having a huge impact on the developments of divorce cases. So being, I think like just teaming up with therapists, mental health, experts and counselors is just learning so much about psychological issues. I think that's the interesting thing that's happening now in family law, because it's something that was never talked about before. We never said narcissism or personality disorders. We never had an open discussion about it like we are having right now. Like now social media and people are becoming aware of the red flags and speaking openly about it, living with a narcissist. And it's different, they're not, a lot of narcissists are not diagnosed, and it's and but we're dealing with them every day. So I think that's a new interesting topic that we're dealing with right now in family law.
Wow, thank you so much for coming online and sharing all of this knowledge today. I really appreciate what you have done in breaking everything down and simplifying it for our audience. And thank you to everybody who's tuned in today. The Her Story Circle is bringing you professionals, people who are here to uplift you, empower you, and give you the knowledge to navigate these tricky spaces. So tune in again tomorrow when I interview yet another amazing guest. In the meantime, have a fantastic day, morning, or evening, wherever you are in the world, and bye for now. Thanks again for the interview.
Thank you for having me.
It's a wrap, everybody, on today's episode of the Diversity Connector podcast. Thank you for tuning in and being part of our vibrant and global conversation. I'm your host, Getrude Matshe, and it's been an honor to share this space with you, where voices from all walks of life come together to weave a tapestry of diverse perspectives. Remember, every story you've heard today is a thread in the larger fabric of our shared humanity. So, as you step back into your world, carry these stories with you and let them inspire you to embrace and celebrate the rich diversity around us. Don't forget to subscribe, rate, and review our podcast to help us share these inspiring stories with more listeners. Do follow us on social media by looking for the Diversity Connector podcast for more updates. Until then, keep connecting, keep listening, and keep celebrating the beauty of diversity. This is the Diversity Connector podcast signing off. Stay curious, stay open, and definitely stay connected.